The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome our panelists today, as well as all members who are present in the room. I'm going to recognize myself for an opening statement and then recognize the ranking member for his opening statement. As the framers of the Constitution understood, Congress has an independent duty to examine the constitutionality of the legislation it considers. Ideally, we should assess the constitutionality of legislation before it becomes law. However, given the unprecedented nature of the health care law's individual mandate, it is important that we examine its constitutionality even though it has already been enacted. The individual mandate, which requires all Americans to purchase health insurance, is the foundation of the new health care law. It is also, in my judgment, unprecedented. 27 states are now challenging the constitutionality of the new law. 2 federal district court judges have ruled that the individual mandate is unconstitutional. 2 have determined that it is not. Ultimately, it will, of course, be decided by the Supreme Court. The individual mandate requires Americans to purchase health insurance from a private company. It does not matter whether they want health insurance or can even afford it. Under this law, Americans must either obtain insurance or pay a penalty. But the Constitution, which creates a federal government of limited enumerated powers, does not necessarily allow Congress to require individuals to purchase any good or service, including health insurance. As Judge Vinson observed in his opinion in the Florida case declaring the health care law unconstitutional, quote, "It is difficult to imagine that a nation which began, at least in part, as a result of opposition to a British mandate imposing a nominal tax on all tea sold in America, would have set out to create a government with the power to force people to buy tea in the first place," end quote. The Obama administration argues that the individual mandate is either a law that is necessary and proper for the regulation of interstate commerce, or alternatively, that the mandate is constitutional because it is a tax. The administration's arguments are supported by neither the original meaning of the Constitution nor Supreme Court precedent. The Constitution gives Congress the authority to regulate economic activity, which includes everything from growing wheat to managing a restaurant to running a Fortune 500 company. But the current health care law wrongly assumes that Congress can also regulate economic inactivity. Neither the Constitution nor the Supreme Court has ever given Congress that authority. There is a difference between regulating economic activity that is ongoing and forcing Americans to engage in an economic activity, in this case, purchasing health insurance. Part of a free society means the freedom to choose not to do something. Never before in America's history has Congress required people to purchase a good or service simply because they live in the United States, at least not until now. If the Commerce Clause allowed Congress to regulate inactivity, Congress could force Americans to buy anything that might conceivably affect commerce in some way. If the housing sector was struggling, Congress could force renters to purchase a house. If the auto industry was on the verge of collapse, Congress could force individuals who take public transportation to purchase a car. Or if falling citrus prices were driving farmers into bankruptcy, Congress could force consumers to purchase oranges. The administration asserts that the decision not to purchase health insurance is unique, because if Americans don't purchase health insurance, the cost of their health care is shifted to the government. But the same can be said of every other type of insurance that people choose not to purchase. There is no end to the number of commercial transactions Americans could be forced into if the Commerce Clause were as broad as the Obama administration argues. Because the administration's Commerce Clause argument is without legal precedent, the administration has argued that the individual mandate is authorized by Congress's power to tax. This argument, however, is an unpersuasive, revisionist justification for the mandate that was not raised until the mandate was challenged in court. The health care law explicitly calls the penalty imposed on those who fail to purchase insurance a penalty, not a tax. As President Obama stated, the mandate is, quote, absolutely not a tax, end quote, and, quote, nobody considers it a tax increase, end quote. Additionally, the mandate's penalty is not listed with the provisions of the health care law intended to raise revenue for the government. And the IRS is prohibited from seeking the same types of punishment for failure to pay the penalty as it does for failure to pay taxes. The arguments in favor of the constitutionality of the individual mandate are unconvincing and, if accepted, would give the federal government almost unlimited power over Americans' lives. In my opinion, the individual mandate is both unprecedented and unconstitutional. We should question any law that appears to violate the Constitution and common sense. That concludes my opening statement. I'm very pleased to recognize the ranking member, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you very much, Chairman Smith. Good morning, members of the committee and our distinguished witnesses present. We are here today to have a hearing on the constitutionality of the individual mandate. You will note that the term individual mandate does not appear anywhere in the bill that is being claimed to have a unconstitutional provision. The Affordable Care Act covers the term a minimum coverage requirement in the bill. There's nothing, the term individual mandate does not appear. Now, I enjoyed our first reading of the Constitution on the floor in the Congress and all of my career here. I hope somebody got more out of it than I did, because reading the Constitution and understanding the Constitution is two different things. I think you could be in about the 6th or 7th grade and you can read clearly enough to read the Constitution. It does not comport with you understanding the Constitution, and that's why Chairman Smith and I have talked about evening classes, or sessions with our colleagues here to talk with experts about certain provisions of the law, of the Supreme Court decisions, and the Constitution itself. And I encourage our meeting and negotiations on that. Now, as a universal single-payer health care advocate, I was not enthusiastic about all of the benefits that accrued to the insurance industry under the Affordable Care Act. I supported it nevertheless. I assume, because of that support, the insurance industry itself supports this so-called individual mandate. And I wonder how they feel about this assault on that portion of the law. Fortunately, the chairman of this committee did not say that consequently that violates the whole act itself. I hope he didn't say that. I didn't interpret him to say that, and he didn't say that. Right. He's and so I am struck by the bipartisan nature of the discussion that's going on this morning here about constitutionality, because you see, many years ago, my colleagues in the other body, Senators Orrin Hatch and Senator Charles Grassley, along with 18 other Republican colleagues, included the notion of an individual mandate in their health care bill of 1993. And I hope someone asks me to prove that, because my staff has researched this. Now, in addition to that, we have other supporters on the constitutional question that are not Democrats. Former Massachusetts Governor Mitt Romney featured an individual mandate as part of his successful health care reform law in Massachusetts, where it helped reduce insurance premiums by 40%, while the national average has increased 14%. Given this demonstrated success and the need to solve our national health care crisis, one would hope that my friends on the other side of the aisle would continue to embrace the idea that has been brought forth by Republicans at an earlier period of time. But unfortunately, they have taken a different course and are now suggesting that the individual mandate is unconstitutional. Now, I would like to cite the Constitution. Congress has the clear power under Article 1, Section 8, Clause 3 of the Constitution, which gives us the authority to regulate commerce between the states. And further, that power is augmented by Article 1, Section 8, Clause 18, which grants us discretion to choose the, quote, necessary and proper, end quote, means of achieving our legitimate regulatory goals. And if I could just begin my conclusion by explaining briefly why our authority here is really beyond question. And I suppose that this hearing today may conclusively determine that. First, the core argument that is put forward by my friends is that this regulates inactivity. Now, what in the world does that mean? To regulate inactivity. It requires us to accept what is really amounts to a complete fiction, because we all participate in the healthcare market. That's one statement I can make. Everybody, from the time they're born until the time we leave this planet, will participate in the healthcare market one way or the other. So no one can claim that they will never get ill or get injured or get sick. We even promise emergency care for all who need it. Matter of fact, we passed a law to say that emergency rooms must take in people who are ill and don't have any insurance and don't have any visible means to pay for the health care that they seek at a hospital. The cost of uncompensated care in this country last year was $43 billion. And those costs, of course, are shifted to other Americans who pay higher taxes and increased fees for medical care and insurance premiums. The individual mandate recognizes the reality that we are all active in the healthcare market and regulates how and when we pay for our health care. Doing so is uncontrovertibly within the scope of congressional power. Now, while some of my colleagues may think talking about inactivity as an argument, I would counter with the statement of former Solicitor General Charles Freed, a Reagan appointee, who said that in any event, it is irrelevant as a matter of law. Solicitor General Freed is not a partisan supporter of the Affordable Care Act, but he is a staunch defender of the Constitution. And in his view, the individual mandate is fully constitutional because Congress unquestionably has the power to regulate the interstate health and insurance markets and the discretion to choose the necessary and proper means of doing so. And so Solicitor General Freed has testified in the other body, and I would ask unanimous consent to enter his statement into the record.
Without objection.
And in conclusion, Chairman Smith, and I thank you for your generosity with the time, we've been hearing a lot about individual liberty, the right to be let alone. But is it really? For example, states can and do require citizens to purchase car insurance. You've got to have insurance to drive a car. In Massachusetts, legislation signed by former Governor Romney obligates the state's residents to purchase health insurance. There are many, many other laws that impose affirmative obligations on our citizenry. We must pay taxes. We must send our children to schools and vaccinate them. Must contribute to Medicare and Social Security, just to name a few in a long list. So I'm pleased to be here today to join in this discussion with the members of the committee, and I thank the chairman for his generous allowance of time.
Thank you, Mr. Conyers. Without objection, other member statements will be made a part of the record. We welcome our panelists today, and our first witness is going to be introduced by the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman, for holding this hearing and affording me the opportunity to introduce our Attorney General. Congressman Forbes and Congressman Scott join me in welcoming Ken Cuccinelli, who was elected Attorney General of Virginia on November 3, 2009, and was sworn into office on January 16, 2010. In this position, he's responsible for overseeing the Office of the Attorney General and its more than 300 attorneys and support staff. Prior to this, Attorney General Cuccinelli served in the Senate of Virginia from August 2002 to January 2010. As a state senator and private attorney, Attorney General Cuccinelli worked to improve all levels of the Commonwealth's mental health system, first serving as a court-appointed attorney for individuals in Virginia's involuntary civil commitment process. After joining the Senate in 2002, he passed legislation that has provided for more humane treatment of the mentally ill and helped family members better cope with treating their loved ones. Best known nationally, however, for having brought the first lawsuit challenging the constitutionality of the individual mandate, a challenge which was successful at the district court level before Judge Henry Hudson in the Eastern District of Virginia. That case is now on appeal. Mr. Chairman, it's my pleasure to welcome a great leader of the Commonwealth of Virginia.
Thank you, Mr. Goodlatte. Our second witness is Walter Dillinger. Mr. Dillinger is the head of appellate practice at O'Melveny and Myers and the Douglas Maggs Professor Emeritus of Law at Duke University Law School. Mr. Dillinger served as Assistant Attorney General for the Office of Legal Counsel from 1993 to 1996 and as Acting Solicitor General for the 1996-97 term of the U.S. Supreme Court. By our joint reckoning, he is making perhaps his 30th appearance before Congress as a witness today, 30th or 31st, something like that. Our final witness is Randy Barnett. Mr. Barnett is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center. He has served as a visiting professor at Northwestern and Harvard Law School and was awarded a Guggenheim Fellowship in Constitutional Studies and has authored 9 books and over 100 articles and reviews. Each of the witnesses' statements will be made a part of the record, and we welcome you all and look forward to your 5 minutes worth of a statement, after which we'll need to move on to the next witness. We appreciate your presence and look forward to the testimony first of Attorney General of Virginia, Mr. Cuccinelli.
Thank you, Mr. Chairman and members of the committee. I will not repeat my written testimony and my oral testimony. I'd like to make 3 points to you all. The first is that what the states are doing, and I'll refer to the states generically, there are dozens of cases running challenging the individual mandate. My focus, obviously, being an attorney general, is on the states' cases. What the states are doing in challenging the individual mandate, and which ultimately will result in a request to the Supreme Court to find that individual mandate unconstitutional, is very modest from a legal perspective. We are not asking the Supreme Court to change any law, to expand or contract any of its precedent, simply to apply the existing law to deny the opportunity to the federal government to massively expand its power to compel American citizens to act. The other side, the federal government, requires to prevail an expansion, as noted by the judges that have even ruled in their favor, an expansion of the Commerce Clause power, which is already vast as it stands under Supreme Court precedent right now. The federal government requires that to be expanded yet again and further in order to prevail in this case. It is the federal government that is asking for a dramatic change to the law, not the states that are challenging the individual mandate. That is the first point I'd like to leave you with. The second point is that this case, while it of course deals with the legislation passed last year that the President signed March 23rd last year, relating to health insurance, health care, and a variety of other things, the litigation is not so much about health care as it is about liberty. And the reason for that is that if the power that the federal government for the first time is exercising in the legislation passed last year is allowed to stand, then it can be applied across the economy and across the lives of our citizens in ways that are not part of the discussion now because they don't have anything to do with health care. The chairman referenced ordering people to buy a car, to eat asparagus or broccoli, vegetable of discussion, changes day to day. Those compulsions were addressed by judges in these cases. They're very legitimate concerns. And until the United States can articulate a constitutional boundary to the power that it proposes the federal government has, it should lose in the Supreme Court because of the vast expansion of federal power. To give you one example, Professor Turley here at George Washington University, I'm sure some of you are familiar with him, in his first op-ed after this case was filed, he noted that if the states lose this case, it is the end of federalism as we've known it for over 220 years. The end of federalism. Federalism, of course, is intended in part to protect the liberty of citizens, ultimately, by the tension established between the federal and state governments. And I would submit to you that the states that are assaulting the individual mandate in court are doing exactly what the founders expected us to do, and that is to check federal power when they overstep the boundaries of the Constitution. That's exactly what we're doing in this case. My third point is more historical. Whenever we deal with a novel question of constitutional law, and this is an unprecedented exercise of federal power, and so the question that the court is dealing with is novel. I'd reference Mr. Conyers' remarks about the inactivity-activity distinction. That has never arisen before because no case the Supreme Court has ever dealt with before has ever had to consider it, because Congress has never presumed to have the power to compel Americans in the way done with the individual mandate. In that sort of a circumstance, we do look back to the founding period. We look back to the writing of the Commerce Clause, and we look back to the context in which it was written. What was the problem they were trying to solve? And if you recall the colonial period, during that time, the colonists engaged in boycotts of British goods. This began in the 1760s with the Stamp Act and the follow-on acts of taxation primarily, but it also included the Intolerable Acts. And a Massachusetts convention in 1768 determined to boycott British goods until the Stamp Act was lifted and the duties imposed by it were lifted. Cross the water to Britain, King George III is furious about this. In a mercantilist economic system, this hurts. His merchants are hurting, his shippers are hurting. And at that time, the Solicitor General and the Attorney General, by tradition, sat in the Parliament, and the Solicitor General was asked in Parliament if what the colonists were doing was treason to boycott British goods. And the Solicitor General responded by saying that while the colonists have come up to the line, they've come within a hair's breadth, they are within the law to boycott British goods. Now, that didn't sit well with a lot of the powers that be in Britain at the time, but the corollary of that is that they could not compel colonists, subjects of the Crown and Parliament, to purchase the goods of their choice. But we now have a president and had a Congress that thinks that they can. Thank you, Mr. Chairman.
Thank you, Mr. Cuccinelli. Mr. Dillinger.
Provisions. Now I can be heard. Thank you. Thank you, Chairman Smith. The provisions of the Affordable Care Act that are at issue in this case are so clearly within the commerce power that there are multiple ways that it is a perfectly unremarkable application of federal power. Yes, it does impose an affirmative obligation as an alternative to paying a 2.5% tax penalty in order to encourage Americans to have minimum health coverage. It is, as Solicitor General Freed, who served under Ronald Reagan, as Mr. Conyers noted, so eloquently put it, this is a perfectly routine application of Congress's power to regulate the insurance market. Now, what is absolutely at stake in this litigation is the provision of the health care law that for the first time prohibits insurance companies from denying coverage to Americans because of pre-existing conditions. The provision that for the first time prohibits insurance companies from denying coverage to individuals because they have a child who's born with a birth defect. This was a very important reform to ensure that Americans could obtain the health care coverage they needed. Of course, when you do that, you create the possibility that people can say, well, I'm going to wait to buy my insurance when I'm in the ambulance on the way to the hospital because they can't turn me down. And therefore, it was clearly reasonably adapted, reasonably related, to use Justice Scalia's language, justifying the use of the necessary and proper clause. It's reasonably adapted to the law that prohibits insurance companies from denying coverage to individual Americans to provide this financial incentive for Americans to maintain minimum coverage. That's all. It's perfectly unremarkable. It is clearly a regulation of commerce, as no one would doubt that Congress has the authority to regulate the terms and conditions upon which insurance is bought and sold, and that this is a very essential facilitation of the requirement that insurance companies not be allowed to deny coverage. What is striking about it is that is there something so remarkable about this affirmative obligation that would mean that it has to be accepted from what would otherwise be Congress's power to regulate these commercial transactions? It's actually no more intrusive than Medicare or Social Security. All three of them, Medicare, Social Security, and the minimum coverage requirements that are called the individual mandate, those three only apply to individuals that go into the economy. The penalty provisions only apply if you go into the economy and earn a sufficient amount, $18,000 for a couple, earn a sufficient amount that you have to file federal income taxes. If you go into the economy and do that, you're required to pay 7.5% of your earnings into Social Security, 15% if you're self-employed. You're required to pay to take care of your old age benefits. You're required to pay a few percentage points for Medicare to provide for health coverage after you're 65, and now you're required to pay up to 2.5% and an additional tax penalty to provide for health care before you're 65 unless you're maintaining minimum coverage. The difference between this approach and what's done with Social Security and Medicare, and the reason it was supported for so long by so many conservatives, is that it offers more choice. Instead of having a single monolithic governmental provider, it allows people a choice among private providers of insurance. That surely is a choice that Congress can make to favor a market approach over a government bureaucracy approach. Is this unprecedented? Has Congress ever, quote, regulated inactivity? Congress, of course, has no freestanding power to regulate inactivity. It has a variety of powers which it can sometimes use to impose affirmative obligations. That's what we're talking about. In 1792, months after the Bill of Rights was adopted, Congress passed a law requiring every adult free male to purchase a weapon, to purchase ammunition, to purchase a knapsack. No one said, oh my goodness, this is a regulation of inactivity, and if Congress could regulate that, we could regulate anything. The reason they didn't is that what it was the imposition of an affirmative obligation where Congress has the authority to impose an affirmative obligation. Now, let me go just right to the question of limits. First of all, this doesn't implicate the Supreme Court's decision limiting Congress's power to regulate non-economic local matters, like street violence or guns within schools, near schools. Morrison and Lopez deal with different issues because this regulates a matter that is entirely economic, entirely commercial. Secondly, does it allow Congress to require the eating of asparagus or broccoli? I wanted a side bet with General Cuccinelli about how many times the word broccoli would be mentioned this morning. Of course it doesn't. The Liberty Clause of the Constitution stand in the way of that kind of imposition of activity on individuals. Does it require the purchase of any other products? Can I tell you, if Congress can regulate this, anything that Congress cannot regulate? I can tell you thousands of things Congress cannot regulate after this is upheld. I brought the yellow pages because if you want me to spend the next 3 days, I can read every product that Congress would not have the power to require you to purchase.
Mr. Chairman, has the opening statement concluded?
Mr. Dillinger, before you read those yellow pages, could you conclude your testimony?
I will.
Thank you.
I will by saying that the justification will be that Congress can require the purchase of a unique product, which is one that no one can be assured they will not use, and which we have complete and total evidence that when people are not insured, they transfer that cost to other Americans, other people who are sick, or to taxpayers. And that is a unique situation where Congress can encourage people to maintain minimum coverage. It would not be a precedent for any of the parade of horribles that come marching through this committee room. Thank you, Mr. Chairman.
Thank you, Mr. Dillinger. Mr. Barnett.
Thank you, Mr. Chairman, and thank you to the members of the committee. Let me begin today with a thought experiment. Imagine that I tell you 100 things that you may not do tomorrow. For example, you may not run on a treadmill, you may not eat broccoli, you may not buy a car, and 97 other specific things that you can't do tomorrow. Now, while your liberty would certainly be restricted, there would still be an infinite number of things that you may still do. All right, now suppose I tell you 100 things that you must do tomorrow. You must run on a treadmill. You must eat broccoli. You must buy a car, and 97 other things. These 100 mandates could potentially occupy all your time and consume all your money. I offer this illustration to help you see why economic mandates are so much more onerous than either economic regulations or prohibitions, and why so dangerous an unwritten constitutional power should not be implied. Now, of course, we all know that Congress may mandate that citizens register for the military and serve if called, submit a tax form, fill out a census form, and serve on a jury. But each of these duties is necessary for the operation of government itself, and each has traditionally been recognized as duties that are inherent in being a citizen of the United States. They're inherent in United States citizenship. In essence, the mandate's defenders are claiming that because Congress has the power to draft you into the military, it has the power to make you do anything less than this, including mandating that you send your money to a private company and do business with it for the rest of your life. To justify this claim of power, implied power, supporters of the mandate say that health care is different or unique. But a factual description of health care is not a constitutional principle. It does not provide any principled line identifying when economic mandates are constitutional and when they are not. Once the power to conscript Americans to enter into contracts with private companies is accepted here, the Supreme Court will never limit it to any particular factual circumstance in the future. From now on, Congress would simply have the power to impose economic mandates whenever it deems it convenient to its regulation of the national economy. So when a defender of the insurance mandate says health care is unique, you need to ask, okay, but what is the constitutional limit on the power to impose economic mandates? Now, some have responded that the Commerce power is limited by the protection of liberty in the Due Process Clause. But law professors know, even if the American people do not, that the Supreme Court now limits the scope of the Due Process Clause to protecting only a very few specifically defined fundamental rights, none of which would include a right to refrain from doing business with private companies. As important, claiming that commerce is limited only by the Due Process Clause or some other express prohibition in the Constitution is really to claim that Congress's enumerated powers in Article I are unlimited except as they are qualified by the Bill of Rights. Such a proposition has always been rejected by the Supreme Court. As Chief Justice Rehnquist wrote in Lopez versus United States, quote, "We start with first principles. The Constitution creates a federal government of enumerated powers." And then he went on to quote James Madison's Federalist 45. And here's what Madison said: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in state governments are numerous and indefinite." As I explained in my written testimony, existing Supreme Court doctrine limits Congress to the regulation of economic activity, and to date has never sanctioned an implied congressional power to regulate inactivity. In other words, the Supreme Court has said that Congress may go this far and no farther. But even if it did, even if the Supreme Court were to uphold this, each member of Congress must still decide for him or herself whether conscripting Americans to enter into contractual relations with a private company is a proper exercise of the commerce power. In 2010, Congress claimed a power that had never before been claimed: the power to mandate that every citizen enter into a contractual relationship with a private company and do business with it or another business like it for the rest of their life. Had this ever been done before, each of you would know all the economic mandates that you must obey upon pain of penalty to the IRS. You don't know of any such mandates because this claim of power is literally unprecedented. For this reason, if you conclude that economic mandates are either unnecessary or improper and are therefore unconstitutional and beyond your power to impose, this conclusion would affect only one law ever enacted by this Congress, the Affordable Care Act of 2010. And this fact makes it much more likely that it will be held unconstitutional by the Supreme Court. Nothing in Judge Vinson's opinion in Florida imposes any new limits on congressional power. For over 200 years, Congress has gotten along without a power to mandate that every citizen enter into a contractual relationship with a private company. Congress has ample means to solve free rider problems by regulating economic activity and devising tax and spending schemes, and does not need this new and dangerous power. Because economic mandates are both an unnecessary and improper means for regulating interstate commerce, the individual insurance mandate is unconstitutional, and I believe Congress should repeal it. Thank you.
Thank you, Mr. Barnett. I'll recognize myself for questions, and Mr. Cuccinelli, I'd like to address my first question to you. You mentioned that if the individual mandate is upheld, you feel that it would be the end of federalism. I gather then that you also feel that if Congress can require everyone to purchase health insurance, that there's really no limit to Congress's ability to regulate under the Commerce Clause. Is that the case?
That's correct, Mr. Chairman. Once you have allowed, sort of kicked open that door, there is no articulable limit to that power. I'm sure I could come up, as Mr. Dillinger mentioned, with examples, what I would call crumbs off the table, that might remain exclusively within the power of the states, but we would have dramatically reduced that sphere. Mr. Conyers, in his opening remarks, referenced auto insurance and the Massachusetts insurance example. Both legitimate examples. I hear questions about them all the time. Massachusetts is a state. The Constitution, as originally written, did not limit states. It limited the federal government, and it is the federal government that has stepped outside those boundaries. Massachusetts can do exactly what the federal government attempted to do last year, perfectly well within its constitutional prerogatives as a sovereign entity in our constitutional system. That's why federalism is so threatened by this legislation, is you completely gut that differential. The distinctive authority and responsibility that was left to the states when the federal government was limited by the enumerated powers. And that's why the language of the 10th Amendment reads the way it does, is that residual power, which we typically refer to as the police power, is still left with states, and it would be gutted if the individual mandate is allowed to stand.
Thank you, Mr. Cuccinelli. Mr. Barnett, supporters of the individual mandate say we don't need to worry because the Due Process Clause puts a limit on Congress's power. Do you buy that argument?
Well, the Due Process Clause does put a limit on Congress's power, and it puts a limit on the state's power as well. And if that's the only limit that's on the state and federal power, that means the Congress's power is the same as the state's power. It's just as broad, if that's the only limit, since it's the same limit on both entities. But we know that that's not right, that Congress has limited and enumerated powers, and the state's powers are broad and diverse. Right. So that can't be the only limit. Essentially what that argument says, Mr. Chairman, is that the enumerated powers in Article 1, Section 8 are unlimited in and of themselves. They're unlimited. And they're only to be qualified by the Bill of Rights or the Due Process Clause. It's like saying Congress's powers are unlimited unless they violate free speech. It's the same kind of argument.
Okay. Mr. Barnett, one more question. Supporters of the individual mandate also say that somehow health care is unique, and therefore we also don't need to worry about excessive power residing in the hands of Congress. Do you think that health care is so unique that that should alleviate our concerns?
Whether or not health care is unique, the factual uniqueness of any particular market is not a constitutional principle. And for 200 years, the Supreme Court has declined to examine the factual reach of any particular congressional law. What they need is a firm line that they can judicially administer, and they don't get into the factual details of this circumstance versus that circumstance. So the problem with that objection is it is not a constitutional limitation. It will never be held as a constitutional limitation, so it doesn't solve the basic problem.
Thank you, Mr. Barnett. The gentleman from Michigan, Mr. Conyers, is recognized for his question.
Thank you, Chairman Smith. First of all, I want to thank the Attorney General of Virginia for his instructions. I will not debate this now because we are short of time, but I wanted to just ask you this question. What is it that two Solicitor Generals, Freed and Dillinger, understand about the constitutionality of the issue that brings us here this morning? What is it that they don't understand and that you do understand? Could you explain that for me?
Mr. Conyers, they, along with many others, we could pile the list of supporters of each position on a scale and it'd be a mile high, but the position they have taken is accepting that there are not no limits, but virtually no limits on the Commerce Clause power of Congress. And you commented earlier on the inactivity focus of us and our attack on the individual mandate. If one can treat a decision to do nothing as activity for purposes of Supreme Court precedent, which even judges ruling in favor of the federal government have had to make that logical leap. That's the leap they have to make. They have to redefine words, and they have to have leaps of language and logic to prevail.
Well,
and they're willing to do that.
I want to assure you that the sky is not falling. I want to give you that assurance today that federalism is probably alive and well before, during, and after the Supreme Court decision on this matter. Now, Mr. Dillinger, can you, do you have a response for Professor Barnett in this discussion that we're having this morning?
Mr. Conyers, I believe that the fundamental flaw in the critique of this legislation, the no limits critique, is that it assumes that a decision by the Supreme Court upholding this law would say that we're upholding this law because, in our opinion, Congress can regulate anything it wants, or Congress can require the purchase of any product it wants. But why in the world would you think that would be what the Supreme Court would hold? Whether a Supreme Court decision sustaining this minimum coverage incentive or requirement would allow Congress to do lots of other things would entirely depend upon what the Supreme Court gave as the reason. And I think, I can't, I'm sure there are ethical rules and criminal rules that prevent members of Congress and witnesses from wagering, but if there weren't, I would wager that not only will this be upheld if it gets to the Supreme Court, that is, if any of the courts of appeals strike it down, which they may not, I would wager that, and I've sampled a lot of other Supreme Court experts, I would wager that Chief Justice Roberts writes the opinion upholding the law. And he's not going to write an opinion that says, we're upholding this law because Congress can require people to buy any product that Congress chooses or engage in any exercise. They're going to uphold it by saying that, in this case, it is intimately intertwined with a fundamental part of the interstate markets in health insurance and health care. And here's what the opinion I expect by the Chief Justice will cite. It will say that 94% of the long-term uninsured have actually utilized health services. It will say that only 1/3 of the cost of health services obtained by the uninsured are paid for by the uninsured. Of hospital costs, only 10% of the hospital costs obtained by the uninsured are paid for by the uninsured. 90% of those costs are transferred to other Americans, other patients who are sick, and to taxpayers. And in those circumstances, when Congress is regulating a market by prohibiting insurance companies from denying coverage, it can surely create an incentive more modest, more respecting of liberty than the way Medicare and Social Security operate, in order to encourage people to maintain minimum coverage. That's what the Supreme Court will say, and it won't be a precedent for requiring any other obligation to purchase anything whatsoever.
Well, I want to assure you that as long as you stay away from internet gambling, wagers are probably permitted in the Rayburn bill. Thank you, Mr. Chairman.
Thank you, Mr. Conyers. The gentleman from Virginia, Mr. Goodlatte, is recognized for his questions.
Thank you, Mr. Chairman. Gentlemen, welcome. This is a very interesting discussion. But, Mr. Dillinger, I have to tell you that while the Supreme Court can write anything they want to in their opinion, they have historically done so from the perspective of what parameters they're going to impose upon what Congress can do based upon that decision and based upon the precedents that have stood before them. And quite frankly, I find it astonishing that you would compare Social Security or Medicare or any other government program which is funded through taxation and then provided to people who can choose to avail themselves of it or not as the equivalent of mandating that individuals buy a private product from a private company, which the government is also going to then mandate to that private company what has to be provided in the product. And I would yield first to the Attorney General and see if he would like to address that point.
Well, thank you, Congressman. I would note that every example that I've heard listed by either Mr. Dillinger or Mr. Conyers, car insurance, Medicare, Social Security, the 1792 Militia Act, that Mr. Dillinger was referring to, all stand on their own constitutional footing, and it is not the Commerce Clause. For none of them. None of them. They all have an independent power provided to Congress. The Militia Act, if you read your Article 1, Section 8, you will see it worded affirmatively, that you may raise an army, that there is vast authority over the militia and how it's to be governed and utilized. That doesn't exist in commerce. You must regulate something that already exists. They may not compel it into being. Car insurance, we already talked about. That's within the realm of states. Medicare and Social Security, as you note, are implemented using the taxing power, a broad, though not unlimited, power of Congress. The other example cited so far is forced schooling, which is within the realm of the power of states, not the federal government. So, you know, none of the other examples are applicable. And I'm one of these. I was an engineer before I went to the dark side and went to law school. So I have this, you know, logical train that that forces me to argue in certain ways, I would say. And all of the discussion of the importance of the subject, I take for granted. I agree this is important. Supreme Court has repeatedly noted that that doesn't matter. It doesn't matter. What matters is, are you within the boundaries of the Constitution? And this isn't even close.
Let me ask you about another argument that has been made by the Justice Department in supporting their case. They've argued that the individual mandate penalty is constitutional as a tax. And could you explain the problem with the argument that the mandate's penalty is a tax?
Well, first of all, let's note that this argument really didn't exist until they began to worry we might actually beat them. And
we were told here that it wasn't a tax.
Right. Well, of course, and rather famously and emphatically, the president with the George Stephanopoulos interview said the same thing, and that was cited by Judge Vinson in his October 14th order in the Florida case. But it's called a penalty. It had been called a tax in an earlier version of the bill. That was changed to a penalty. The Supreme Court has noted, LaFranca, there is a distinction that matters between taxes and penalties. The taxing power, as I already mentioned, is broad for you all, for Congress. However, it is not unlimited either, and the money you must pay if you fail to obey the government diktat and buy their chosen health insurance is a penalty. It is a punishment for failure to comply. That's a penalty. It was called a penalty. It acts as a penalty. In form and substance, it is a penalty. To rename it after the fact, in court, a tax doesn't change its form or its substance, and it does not generally raise revenue as the money raised for Medicare and Social Security do. That's why those stand just fine. And it is an argument that not even the two judges who found the individual mandate constitutional have bought. I would suggest to you that if all you have to do, and you here as Congress, if all you have to do is penalize me some amount of money if I don't obey whatever you put in the legislation, whatever legislation it may be, and that can survive under the taxing power, that is a truly radical argument in terms of federal power. That is radical. And it is not being upheld by any judge anywhere. And playing along with Mr. Dillinger's wagers, I bet you that not a single judge in America upholds that argument. They may uphold the individual mandate. It's going to be a close call. But they will not uphold that taxing argument.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Goodlatte. The gentleman from New York, Mr. Nadler, is recognized for his question.
Thank you. I'd agree with Mr. Cuccinelli. I don't think anybody will uphold that argument because they'll never get to it, because they'll decide the case is valid, the law is valid on the as an expression of Congress power under the Commerce Clause. But before I begin my questioning, let me ask the Chairman for unanimous consent to enter into the record the testimony submitted for today's hearing by the Attorneys General of California and Oregon, Kamala Harris and John Kroger. Like Attorney General Cuccinelli, they are involved in legal challenges to the Affordable Care Act, but they defend the constitutionality of the law and herald it as a much-needed solution to their state's and our nation's health care crisis. Having their perspectives will be useful to our consideration of this issue.
Without objection.
Thank you. I'd now like to start the questioning. Yes, Mr. Cuccinelli. Yeah, a number of our laws impose affirmative obligations on citizens. We must all pay taxes, buy car insurance, send our children to school, vaccinate them. Yet critics of the Affordable Care Act proclaim that this law, not any of these other existing affirmative obligations, signals the end of liberty as we know it. And they posit various hypotheticals, raising questions about government forcing citizens to eat leafy greens or to exercise, both, from my perspective, perhaps objectionable. Can the states require residents to eat broccoli or require them to exercise, Mr. Cuccinelli?
I'm sorry.
Can Virginia require someone to eat 2 ounces of broccoli a day?
I think they could certainly order people to buy broccoli.
Can they require them to eat broccoli?
I think that's a more difficult question.
But they could require them to buy them.
And the federal government cannot.
Now, if you say that presumably what you're saying is that under the police power, the state can order that.
That's correct.
And the federal government doesn't have the police power.
Correct.
Okay.
Well,
but if that is correct, if the state can exercise its authority to order someone to buy broccoli or to exercise, then the quarrel here is not about individual liberty, such as you've talked about. It's not a question of the liberty interest under the Fifth Amendment, but it's a question of who gets to exercise that authority. If the state can order it, then that's not protected by the Fifth Amendment, or the 14th for that matter. And the question then is, since somebody can order it, the question is who can exercise the authority which concededly is not limited by the liberty interests of the Fifth Amendment. And so long as we act within an enumerated power, which I would contend we do here, does Supremacy Clause answer that question as well in favor of Congress?
Mr. Naylor, I would acknowledge that if you take the broccoli example and say the state government can order it but the federal government cannot, that there is the potential within each of the 50 states for the citizens there to be burdened with that obligation.
No, but my question is not that. The question is, isn't your argument that Congress is limited by a liberty interest here, negated, and that the question has nothing to do with the liberty interest of the Fifth Amendment? The question is simply one of how far the Commerce Clause power extends, which is not a liberty question, but is an enumerated powers question. Yeah, and the liberty question is therefore really a red herring.
This case is about liberty, not health care. And the reason that the distinction you're making doesn't address that problem is that the federalist system of sovereignty, states and federal being separate and having separate spheres of authority, is intended to be a structural protection for liberty. So the fact that the states still have this reservoir of power and authority does not change the fact that the division of that power and authority is a protection for liberty.
But of course, that argument
is wiped out if the individual makes
that argument that you just made has been specifically rejected numerous times under the Supremacy Clause jurisprudence of the Supreme Court. Let me ask Mr. Dillinger,
Congressman.
Let me ask Mr. Dillinger briefly to comment on what Mr. Cuccinelli just said. And on my contention that if a state can force you to eat broccoli, then it's not a question of liberty. It's simply a question of whether Congress can do something under the Commerce Clause or not. There's no liberty interest question here.
That's correct. That I think there's no issue of liberty since in anything the states could do and the federal government could do. There is sort of an let me give credit to the other side by saying that there is the following question. What I think they misname the regulation of inactivity is actually the imposition of an affirmative obligation in an area where Congress has power, jurisdictional authority to legislate. Now, I think as Professor Barnett, who's been one of the great advocates
let me just interrupt you for a second because my time is about to run out. This whole question of the inactivity and the liberty interest of inactivity, et cetera, wasn't that disposed of really by Wickard v. Filburn when the court specifically said, in 1942 I think it was, that the federal government under the Commerce Clause could regulate the private production of wheat for his own, for the farmer's own use, and that affected interstate commerce because if he didn't grow it, he would buy it from someone else. And the court there is saying, in effect, Congress has the right to prevent an inactivity, namely that he wouldn't buy it from someone else?
I think, yes, that essentially Wickard is the case in which the court recognized that Congress is encouraging people to make a purchase in interstate commerce who would have preferred not to make such a purchase.
The gentleman's time has expired, and the gentleman from California, Mr. Lundgren, is recognized.
Thank you very much, and I hope my friend from New York will pay as much attention to the opinion of this Attorney General of California as he does to the new one, but I may be asking for too much. You know, I'm sorry. Even though I went to law school at Georgetown and practiced law and was Attorney General and argued a case for the Supreme Court, sometimes we seem to make these things so esoteric that the average person is left out. That is, only those of us with coats and ties on or judges who are, you know, attorneys with robes on can really make sense of this. I always thought that the intent of the Founding Fathers was to have a limited government. And I always thought that one of the defining issues of limited government was the power to compel. That is compulsion. And what I don't understand, and with due respect to you, Mr. Dillinger, because I respect you and I've liked your opinions many other times, I don't understand why you so easily find that the power of the federal government in this instance is closer to the power to compel one to defend the country, including compel performance in the armed forces by way of a draft, as opposed to the liberty interest that's explicitly expressed in the Fifth Amendment. You can't be compelled to testify against yourself. Now, I know we don't have a specific amendment that says Congress cannot compel an individual to buy a product. But I thought if there's any essence of the sense of liberty, it would be that. And I'm a little, put off a little bit by your argument. It almost seems to me that you're saying that because there's a constitutional end, you can use a constitutional means to get there. That the Commerce Clause is so elastic that if there's any way we can shoehorn anything in, then Congress can use the power of compulsion to do that. And your opening statement was emotional about what we want to do about those who have pre-existing conditions, but it didn't go to the constitutional question about whether, therefore, we can do that. I mean, I've told my friends here on this panel many times, the Constitution is the truly inconvenient truth. You may want to do it, but we don't have a right to do it. And I'm really, I'm surprised at this, and also as your argument about, and even Mr. Cuccinelli's argument about the difference between the state and the federal government. If you think of a liberty interest and you read the 10th Amendment, the 10th Amendment seems to say, at least to me, that there's a whole area of activity that is left to the states and the sovereignty of the people. So if there's a liberty interest with respect to an individual, the 10th Amendment says that is to be expressed and protected by the sovereignty of the people within the states, which would say there's still a liberty interest, but the concept of protecting it on the state level is left to popular sovereignty. Now, I know that may not be the current thinking with some, but can you help me with that? How do you so easily find that we have the right to compel someone to act in this way to purchase a product, particularly when you say no one can escape being part of the system and therefore everything I do affects everybody else? Well, you know, there are people who don't believe in doctors and don't go to doctors. And there are people who are hermits and somewhere who will never utilize these services. And there are other ways to do this, by the way. One of the ways you could do it, I'm not saying it's the most practical way, but you could say we understand that there are, for instance, young people. We want to get young people in, and they don't do it because they make a bet that on average they're not going to be sick like the rest of us. And that's a pretty good bet, but when they lose it, they have to pay. One of the ways you could do it to incentivize young people to be part of it is to say, if in fact you have an illness, if in fact you have an accident, and you are taken care of, and there are bills that are incurred, you will never be allowed to discharge that in bankruptcy. That will follow you the rest of your life. Now, that is one incentive, one way of doing it that doesn't get into the question of the liberty interest. And so are you saying that ultimately, as long as you can shoehorn something within the Commerce Clause, we have no protection against the government's compulsion?
I'm sorry, we have no protection
Against the government's compulsion, as long as Congress decides that we're going to compel you in a certain way.
Well, first of all, let me correct one statement that you made. I have never taken the position that this is in any way like the solemn responsibility Congress compels from time people to engage in military service. That's not.
No, that was my metaphor to say that within that, those parameters, on the one side, we all recognize that in order to have a government work, a society work, we can compel people. On the other hand, we have expressed in the Fifth
I ask
Amendment.
unanimous consent that the gentleman be given an additional minute.
Without objection.
I respond. Thank you,
Okay,
Chairman.
so I wasn't saying you were, but I'm trying to say it seems to me those are the two edges of the question. And I think you easily go to the one side, and I would say I find it very difficult to get that way.
Look, you said we ought to put this simply so that people can understand it, and I agree. I think Ronald Reagan, Solicitor General, was chosen by President Reagan because he had a very good capacity to put things simply. And what Charles Freed said was, this is a regulation of an interstate commercial transaction. It's a requirement rather than a prohibition, but it's still a regulation of commerce, and Congress has the power. Now, the question is it so intrusive because it is an affirmative obligation? And I think that's a serious question, because affirmative obligations, as Randy Barnett has noted, affirmative obligations are more intrusive than negative prohibitions. So I think you could well argue that just because something has some influence on commerce, if it's an affirmative obligation, Congress needs to have a better reason than that. But unlike any of the 1,000 products mentioned here, this is in the yellow pages or in the Sears catalog. This is a product where Congress can simply say 94% of the people have used health care for the long-term uninsured, and we can therefore create a financial incentive. That's all it is, a financial incentive to participate. Is that intrusive in liberty? Mr. Goodlatte said it was astonishing that I would compare it to the use of the tax power for Medicaid and Social Security. What I find surprising is the notion that there's a constitutional rule that the only way Congress could deal with a situation like this would be to provide a monolithic government-provided, taxpayer-supported system, rather than having the same kind of or even lesser incentive to purchase a product in a private market. That seems unremarkable to me.
The gentleman's time has expired. The gentleman from Virginia, Mr. Scott, is recognized.
Thank you, Mr. Chairman, and welcome, Attorney General. Mr. Dillinger, one of the things that your testimony has kind of talked around it about what we call this thing, and it's always intrigued me that the label is so important. People pretty well accept the idea that if you go to a gas station with a credit card, it should be prohibited to charge you extra for using the credit card. However, people think it ought to be permissible to have a cash discount. And so if there are two prices, one, a credit card price, and then a lower cash price, if you call it a penalty for using a credit card, that's bad. But if you call it the same differential, if you call it a cash discount, then that should be permissible. And it seems to me that we're in the same situation on what we call this thing. There's no mandate. If you don't have the insurance, you pay the tax. If everybody's paying the tax, if we'd call this thing a tax credit for having insurance, would that have made a difference? Because there's no mandate and calling it a tax credit for having insurance, that would mean that Mr. Cuccinelli couldn't label it a mandate and couldn't label it a penalty. If you called it a tax credit, would that have made a constitutional difference?
I don't think it should, because even when you consider it as a Commerce Clause matter, the fact that it's clearly within commerce and would be unremarkable if it were done unmistakably as a tax credit for having coverage rather than an additional tax penalty for not having coverage, it seems that that is very deeply non-intrusive. You know, your notion about
Well, but that's what we're here about. We're here about the penalty, the mandate. If we had called it a tax credit, would it have made a difference?
It shouldn't, and it just would have changed the rhetoric.
Mr. Cuccinelli, would it have made a difference if we'd called it a tax credit?
As I mentioned earlier, if the structure was as it is now in the bill, and you change the word penalty to, negative tax credit or something, the substance is still the same, and it is the substance that the Supreme Court has looked to historically. It does not operate as a tax, therefore it is not a tax, therefore it does not fall under the taxing and spending power for the general welfare.
Well, I mean,
so
you get
it
a
will
tax
have
credit.
to
You get a
survive
tax
on some other basis.
You can get a tax credit for solar panels. Well, you don't have to buy a solar panel, but if you do, you get a tax credit for it.
Well, the critical distinction in your point, and it goes to the earlier sort of shift from Mr. Nadler over to Wickard v. Filburn, is yes, but if you compelled the purchase of solar panels, we'd be in a totally different category. And much like the Wickard case,
we don't compel the insurance. If you don't have insurance, you pay the extra tax. So you get a tax credit. You don't have the tax credit for insurance.
You do, in fact, compel it, and you provide a punishment for those who don't obey the compulsion.
That's exactly
the Wickard case, the wheat case, I'm sure you all are familiar with, would have been like this legislation if Wickard was compelled to grow wheat. He was not, but he chose to do so and therefore was governed because his activities, voluntarily engaged in, were subject to regulation under the Commerce Clause.
And you have labeled it a mandate when there's no mandate. You don't have to buy insurance.
Well, if you don't, you're not obeying the law.
You pay the extra penalty. Is that, Mr. Dillinger, is that? If you don't have insurance, you have to pay the tax. You don't get the tax credit. And if we'd label this a tax credit for having insurance, we wouldn't be here.
Well, you still have the structural problem of the legislation as it is. The words on it, if I could ask you,
if we'd had a different differential, those with insurance will pay. Will pay. Those without insurance will pay a tax. Those with insurance get a tax credit, and will not have to pay that extra tax. Would that make a difference?
Well, you give tax credits for various forms of insurance that are purchased, and,
That's right.
and at least that tax credit, standing on its own, has never been challenged, so far as I know.
So, Mr. Dillinger, if we'd labeled it different, would we have a different conclusion?
I think your question very effectively points out the fact that this simply isn't very intrusive. If it's just the flip side of providing a tax credit, a modest tax credit for maintaining insurance, by having instead a modest tax penalty for not maintaining insurance, how is this the end of liberty as we know it? You know, it's...
well, is it true that there's not a mandate to have insurance?
Well, there is a freestanding requirement in the bill, precatory requirement that everyone should have coverage unless they already have Medicare or Medicaid or they're below the poverty level.
And
the penalty provision, you can only applies to people who engage in certain activities, which I'll describe. But you can search the bill for the word individual mandate. It nowhere appears. You can search the bill.
So do you have the difference? If we'd labeled it tax credit, we would have avoided a lot of this controversy.
Absolutely. And it can't be that a mere labeling like that is something on which turns some great issue of liberty. If you ask an ordinary person to say, look, if you're sitting out in the woods, you don't have to buy insurance because there's no penalty that attaches to it. If you go to work in the economy, they're going to deduct money for Social Security for your old age. They're going to deduct money for your Medicare, for health care after you're 65, and they're going to add a 2.5% tax penalty to pay for coverage before you're 65 unless you're maintaining minimum coverage. No one's going to say, well, gosh, one of those is the end of liberty as we know it, and the other two are all right. In fact, this argument sounds exactly like the arguments over the challenge to Social Security. And those attacking Social Security said, if Congress can mandate a retirement age of 65, financial support for those over 65, they could set the retirement age at 30 or 25. The Supreme Court said Congress is never going to do that. That doesn't mean it's unconstitutional. People said when the minimum wage law was passed, if you can have a minimum wage of $10 an hour, why couldn't Congress set a minimum wage at $5,000 an hour? And once again, the court said Congress is never going to do that. That, I think, really hardly counts as an argument. But no one would think of this as unremarkable. No one is going to go with bayonets and force march you to some insurance agency. It's just a financial incentive to maintain minimum coverage, as your questions point out.
Yeah, the gentleman's time has expired. Thank you. The gentleman from Iowa, Mr. King, is recognized for his questions.
Thank you, Mr. Chairman. Appreciate this hearing today, and I think that there have been a tremendous amount of instructive testimony that's come out from each of you. And I look at the bookends Mr. Cuccinelli and Mr. Barnett have made, I think, the arguments that I would be making. And so rather than turn directly to either one of the gentlemen, I'd go to Mr. Dillinger, who probably hasn't quite had enough time to air his position. And I would first take it to this point as I listened to the discussion about Wicker v. Filburn, and we got a couple of follow-up questions for you, Mr. Dillinger. So I just ask, do you believe that Wicker v. Filburn was justly and rightly held?
I do.
And rather than go into my disagreement with that, I think that expanded the Commerce Clause beyond the intentions of the Founding Fathers or the concepts that we basically hold today. Then would you describe what you think if Obamacare is upheld as constitutional and the provisions of the Commerce Clause are, you might argue, not expanded, I would argue they would be expanded if that were the case, then what could be constrained by the Commerce Clause? What type of activity would be constrained? Where would the boundaries be?
That's a very good question. And it would depend, of course, on the kind of opinion the Supreme Court wrote upholding the law. In my view, the Supreme Court in upholding it will say, first of all, nothing we uphold today gives Congress any power to regulate local non-economic matters unless they have some special showing of relation to interstate commerce. So nothing we hold today undercuts United States versus Morris, United States versus Lopez, regulating local non-economic matters is something Congress cannot generally do. Secondly, they would say, we think when Congress imposes affirmative obligations, it has to show that that's really tightly related to, that I expect them to say, Congress has to show that there is a substantial relationship to a regulation of commerce. And the substantial relationship here would be that this is part and parcel of a regulation of insurance contracts that prohibits denial of coverage for pre-existing conditions to provide a financial incentive for people to participate. It does not provide, our opinion today, they will say, does not mean that Congress could simply require anyone to purchase anything in order to stimulate the economy.
Okay, and then quickly, before I go to Mr. Barnett, could you tell me the distinction? I just heard the language used, health care and health insurance, and the distinction between the two was blurred in your opening testimony. Could you just draw a distinction between the two?
I think both of those markets are markets, obviously, which Congress can regulate under its commerce power. They account for 1/6 of the national economy. Health care is unique in that no one can decide not to utilize it. Health insurance is how you pay.
Would you agree that it's been a practice to conflate the two terms, and it makes it difficult for us sometimes to sort the two when we use the term health care interchangeable with health insurance, and we should do a better job of being careful how we use that terminology? Well, let me just make that a statement because the clock's ticking. I thank you for your testimony.
Yes.
And I turn to Mr. Barnett. Would you care to respond to the response that you've heard from Mr. Dillinger, Professor Dillinger?
Yeah. It's what I said in my opening statement, Mr. King, and that is that we've heard no principle of no constitutional principle. The Supreme Court will write, if they uphold this bill, they'll write an opinion. They'll talk a lot about health care is different, but then they'll say we must defer to Congress's assessment that this was necessary in order to impose insurance requirements. So they'll defer to you. Is basically what the opinion will be how it will be written. They will not identify a limiting principle if they uphold this bill. At least we have not heard from any of the proponents of the bill a constitutional principle that the Supreme Court could enunciate. If they say health care is different, what I'm saying that to you is that never in the history of this country has the Supreme Court gotten into a factual determination saying, okay, well, health care is different, that's okay, but this other market for cars, let's say, that's different. There's a constitutional difference between the two. They haven't ever said that, and they're not going to say that.
They're likely then, if the Supreme Court upholds, then they'd leave the discretion to Congress to define, because they'd be reluctant to. Mr. Cuccinelli, you add to that?
I would just say that I'll bet you that Professor Dillinger would take that bet, that he would not want to take the bet that if the Supreme Court upholds the mandate, that they won't say that in the future it's up to Congress to decide whether to impose mandates.
General Cuccinelli?
Well, actually, Mr. Dillinger and I were on a panel in October at the Washington Legal Foundation, and when he was asked the principle at that time, he said the limits would be political. And I agree with him. I think that is the absolutely dead-on, accurate, honest answer, and that means majority rules. And if that's the case, why have a Constitution in the first place?
I'll accept that as a closing remark and yield my time back to the chairman. Thank you very much.
Thank you, Mr. King. The gentleman from Georgia, Mr. Johnson, is recognized for his question.
Thank you, Mr. Chairman. I was in the process of formulating my thoughts here, but let me ask, or let me note the fact that, Mr. Cuccinelli, you have opined that states have the power to mandate that an individual purchase insurance. That's what you said as far as Massachusetts is concerned. Is that correct?
Yes, sir, that is correct.
And you've also stated that your state, the state of Virginia, has the power to compel or mandate that its citizens purchase broccoli.
I think that's probably correct, yes.
And that it can compel them to actually eat the broccoli.
No, I didn't go there.
Okay,
I don't think so.
Just compel, just to purchase the broccoli. What provision of the Virginia Constitution would authorize the state of Virginia to compel its citizens to purchase broccoli?
Congressman, you wouldn't find it in the Constitution of Virginia. The power resides with the states, best articulated in the 10th Amendment. It is a power not given to the federal government, and therefore it's left to the states and the people under the 10th Amendment.
Well, if the state has the power to compel its citizens to purchase broccoli, where does it get that power from? Is it an express power, or is it an implied power in the Virginia Constitution?
It is not in the Virginia Constitution. It is a residual power remaining in the states because it was not given from the states to the federal government when the Constitution was written, and so it stays with Virginia.
Well, you realize that probably some individuals in the state of Virginia would argue that since the power to compel a citizen to purchase broccoli is not stated in the Constitution expressly, then it has been left to the people themselves, that power. You realize that, correct?
I would agree with that statement with respect to the federal Constitution, but the state constitutions, and Virginia's in particular, is not, it lays out not only what the governmental structure would be, but it is not formulated like the federal Constitution to be a specific list of enumerated powers.
Well, in the federal government, I would argue to you, because times have changed since the enactment of the Constitution and its amendments. Times have changed, things have grown, the concerns and affairs of the government have grown and expanded, both state and federal, and they're much more complicated now than they were back in the 18th century. Is that correct?
Absolutely undeniable, Congressman.
And so therefore we have to have an ability to interpret the Constitution with a understanding of how it applies under current conditions. Isn't that a reasonable proposition, or should we just stick with a strict authority or strict interpretation of the framers of the Constitution, what they intended at the time? Because even the Supreme Court didn't do that in the Citizens United case, did they?
Congressman, you're looking to change interpretations with changing times, and I would suggest to you that the proper course is to amend the Constitution if some alternative power is believed to be more necessary or appropriate to our time that was not originally granted to the federal government among the enumerated powers in the Constitution.
If one of Virginia's citizens said that we should, that the state of Virginia does not have the power to force me to purchase broccoli unless it goes and gets a constitutional amendment which would authorize it to do so, would that be reasonable?
As a policy matter, perhaps not, but as a constitutional matter, they could pursue that through the General Assembly, and if they got a bill, it would, I suspect, stand up under the Virginia Constitution. Now, I didn't.
Well, I tell you, I believe what we're doing is we are arguing for states' rights when it's politically expedient to do so, and then when the federal government wants to regulate something like the ability of states to determine whether or not damages in medical malpractice injuries should be capped or not, then it's okay for the federal government to come into that kind of a situation and legislate. And so it's politics. And that's what we have here with this health care argument in the courts. And unfortunately, due to the activities of a couple of our Supreme Court justices and how close they are to the Koch brothers, I am disappointed at the specter of politics coming into a decision by the U.S. Supreme Court on this very issue. And with that, I will yield back the balance.
The gentleman's time has expired. Let me say to members that one of our witnesses, Mr. Cuccinelli, is going to have to leave in 15 minutes for a prior engagement.
Parliamentary inquiry.
But we will at least be able to have 3 more rounds of questions.
Parliamentary inquiry, Mr. Chairman.
And the gentleman from California.
I know under the rules of the House, one is not allowed to call into question the motivation of a member of Congress in the House or the Senate or the President of the United States. Does that rule of the House also refer to members of the Supreme Court?
Yes. I think the gentleman may have referred to politics, and I'm not sure that accusing someone of politics is impugning their character, so I would say it does not apply in this case. The gentleman
Mr. Chairman, there was a specific reference to particular individuals and decisions made by members of the Supreme Court, and one would believe that was a question of motivation. And I know my objection is not timely, but I believe that the gentleman's words could have been taken down under the ruling of the parliamentarian in past decisions.
Well, as the gentleman says, his objection is not timely, but in any case, I'm sure that the gentleman from Georgia did not intend to impugn the integrity of members of the Supreme Court, either individually or on the whole. And if the gentleman from Georgia would want to comment on that, he's welcome to. If not, we'll move on to questions.
I didn't comment. I appreciate that, Mr. Chairman. And just to clear up, I did not comment about what the Supreme Court has already ruled. It's what I fear that they may rule. But this matter may not even get to the U.S. Supreme Court. We'll have to see.
Okay. Thank both gentlemen. We'll now recognize the gentleman from Indiana, Mr. Pence, for his questions.
Thank you, Mr. Chairman. I want to thank you for calling this hearing on what I think is perhaps the most important constitutional question since I arrived on the Judiciary Committee in 2001, and that is this question of whether or not the federal government has the power under the Constitution of the United States to order Americans to purchase goods or services, whether they want them or need them or not. And I want to thank this panel, General Cuccinelli, who I greatly admire for his thoughtful testimony, Professor Dillinger and Professor Barnett. This has been an important discussion, and I expect it is. We've now added the Judiciary Committee to a chorus of kitchen tables around America, small tables in diners over coffee, as this is an argument the American people are fully engaged in. And I think it's an enormously important debate. And the disposition of this debate, I think, will bear greatly on the liberties of our people for generations to come. Professor Dillinger held up the phone book and prepared frighteningly to begin to recite various goods and services that could never be compelled by the federal government. And while that list may be long, and I assume good faith by the witness, I fear that that list of what would be included would be longer than any American today would ever imagine, meaning those things that could be regulated. I want to associate myself strongly with something that you said, General Cuccinelli. You quoted Professor Jonathan Turley, who said, if the states lose this case, it is the end of federalism. Let me say, I think the effort by states like yours, like my own beloved Indiana, 27 states in all, challenging this unprecedented exercise of federal power represents potentially the rebirth of federalism.
I hope so.
In America. And I leave that maybe for another hearing, Mr. Chairman, but I think something very special is happening in America today. And it's something that I believe our founders would have, as you said, General Cuccinelli, I think they would have greatly identified with the notion that states ought to, by definition, they should feel obligated to defend the liberties of the people and defend their own prerogatives as a means of ensuring the ongoing vitality of the limited government enshrined in the Constitution of the United States, and most especially defined in the 10th Amendment. I want to say specifically on this issue of regulating the market, and Professor Dillinger, I think you and I vigorously disagree on this, but I have great respect for your career and for your intellect. Let me just stipulate, you will never convince me that the Constitution of the United States gives this government the power to order Americans to buy health insurance. You'll never convince me of that. So I don't want you to spend a lot of energy. You don't even have to come over here.
No, he was going
I was going to leave and
Let
go
me
get
just tell
lunch.
you, it's not going to happen. But it's important to me to understand your thinking on this. You actually said this fell in your judgment, this individual mandate in this legislation fell within I think you used the phrase, the routine power to regulate the insurance market. And I guess the question, this is a very sincere question, that sometimes we do more posturing here, but I'd love to know your answer to this question. And that is, how does regulating a market include compelling people to participate in that market? I mean, it just does seem to me that you make a point that the Commerce Clause contemplates an orderly regulation of the federal government of commerce between the states. But is it your view that the government, if the government has the power to regulate the insurance market in this country, that by definition that also includes the power to compel Americans to participate in that market?
That's Solicitor General Charles Freed's view from the Reagan administration, that purely and simply, just as the Supreme Court held in 1905, that prohibiting interstate commerce was a regulation of commerce, prohibiting the shipment of lottery tickets in that case. So you can either prohibit commerce or require commerce. Either way, you're setting the rule for commerce. I don't think you need to, and I don't think the Supreme Court would actually reach that question, because I think they would simply say regulating existing insurance contracts by forbidding pre-existing condition denials, for example, is clearly a regulation of commerce. And the only question is this, to use the court's phrase, Justice Scalia's phrase, reasonably related to that regulation? And secondly, that this is a market in which Americans will already participate, cannot choose not to participate, and the facts show very substantially transfer the cost to other people. Now, let me acknowledge that when I say this is a routine application, I think you're right to raise a question about that. Let me acknowledge that in the following sense. While it's well within the commerce power, imposing affirmative obligations may very well demand a stronger level of justification. And I think what the Supreme Court would say is that there are three limits on Congress's power. First is political. That is, it's the only thing that prevents you from adopting a minimum wage of $5,000 an hour. I guess there's liberty. Secondly, there's Liberty Clause objections and Bill of Rights objections. And thirdly, I think where Congress is imposing affirmative obligations, you might need a special justification. You can't just simply say, making people buy something would help that company, it would help the economy, therefore they can willy-nilly buy something. As Randy Barnett said, a Supreme Court decision upholding this would talk a lot about the uniqueness of health care. It's the one market where federal law requires people to provide you with a service, whether you're going to pay for it or not, and transfer the cost to other people. And therefore, it's uniquely one where you could justify requiring people to maintain coverage.
The gentleman's time has expired, and the gentleman from North Carolina, Mr. Watt, is recognized.
Thank you, Mr. Chairman. I actually wasn't intending to ask questions. I came back to thank my good friend, Mr. Dillinger, and the other two witnesses, of course. But my relationship with Mr. Dillinger goes back a long, long way to North Carolina. So, but I can't resist the rare opportunity to that I have to agree with Mr. Pence on a couple of issues. First of which is this is important for the judiciary to have the hearing about, even though in no sense will we be the final word on this. It's working its way up through the courts. There's substantial division of opinion about it. And ultimately it will be decided by the United States Supreme Court. I think it's important for me to agree with Mr. Pence that this is an important hearing for the Judiciary Committee to have. It's important for me to agree with him that Mr. Dillinger has had a long and very bright legal career, and we thank him for that. And I hope we have some agreement on one other thing, because Mr. Pence and I over the years have had pretty strong feelings about one thing. And one comment he made, the comment that says, "You will never convince me that this is constitutional." I've kind of been in that position one time myself, on the short end of a 434 to 1 vote on an issue that I thought was unconstitutional, and that the Supreme Court ultimately disagreed with my view on. I hope that once the Supreme Court, if it does say this is constitutional, maybe that will convince him, because I had to have an attitude adjustment on that issue once the Supreme Court ruled. I had to come back and vote for some things. I had to implement, to vote for funding for something that I had previously thought was unconstitutional. And I hope we have the agreement that his never, ever, ever, Walter Dillinger won't convince me, doesn't apply also to the Supreme Court, because he's going to be out there possibly in a very difficult position. Having been there myself, I can attest to that. With that, I mean, this has been a great hearing. I'm glad I got to hear the witnesses before I had to go off and hear witnesses in another committee. And I'm glad I got a chance to come back and at least express my appreciation to the chair for having the hearing, and to position myself in a similar position at the opposite end of a spectrum from Mr. Pitts, but nevertheless, the dilemma is the same. I mean, we try to do what we believe is constitutional. There's no way we would have been able to convince Mr. Pence or others that this was a constitutional undertaking. But at some point, the Supreme Court's going to resolve this question, and we all going to have to live with it one way or another. And I hope the American people and the Congress will get on with it and hopefully provide health care to all of the American citizens, if that's the ultimate outcome. So with that, Mr. Chairman, I yield back.
Thank you, Mr. Watt. Mr. Cuccinelli, thank you for your testimony today and for spending as much time as you could with us, and we understand you have to leave.
Mr. Chairman?
May I just thank Congressman Watt for something that in my own legislature in Richmond I don't always see, and that's a commitment to upholding your oath. If you think it isn't constitutional, to voting against it. I do not see that enough, and I don't have I'm not here with you all, I'm in Richmond, but my friends don't always abide by that. They kick it to the court and say that's a decision for the court. Read your oath, and I really appreciate, Mr. Watt, you fulfilling that oath in that way.
Mr. Chairman? Mr. Chairman?
Mr. Chairman? Thank you. Wait, the gentlewoman from California is recognized out of order.
I appreciate that, and I understand that the Attorney General has to leave. I did have questions for him, and I'm wondering if I may submit those questions to him in writing and get his agreement to answer them.
Ma'am, absolutely. And if we can ever help any of you all, even if you if you may not agree, we're happy to help talk through subject matter with any of you all to try and be as helpful as we can as you try to do your job as you see fit.
Mr. Chairman?
Mr. Chairman?
Thank you, Ms. Loughran. And let me say to all members that
Mr. Chairman,
it is a part of our regular order of business that all members have 5 legislative days to submit questions to the witnesses, or to the chair, I should say. We will submit the questions to the witnesses and get their responses in time to make them a part of the record.
Mr. Chairman?
The gentlewoman from Florida is recognized.
Thank you. Mr. Chairman, if Attorney General Cuccinelli, I'm the next Democrat to ask a question, and my questions are of you. So do you have an extra couple of minutes? So that
I will. I brought my running boots. So
thank you very much. I appreciate it.
Actually, the gentlewoman from Florida is not the next person to ask questions. That would be Congressman Franks of Arizona.
Mr. Chairman, I said I was the next Democrat.
Okay. And okay, the gentleman from Arizona, Mr. Franks, is recognized.
Well, thank you, Mr. Chairman, and because General Cuccinelli has been so kind as to stay a little longer here, let me first start out. Thank you for reminding us of our oath. You know, we don't make an oath we swear to uphold and defend the Constitution, not adding the words unless the Supreme Court thinks otherwise. And I'm grateful to you, because that indeed is one of the great geniuses of this country, is that when we trifurcated this government, where all of us would have to have some tension between us if necessary to maintain the great principles of the country, and I'm grateful to you, sir. This debate over the individual mandate, I believe, is a big one, Mr. Chairman. I know that Professor Dillinger has expressed sort of the general thought here that, and I don't quote him, I paraphrase, that no one can escape being part of the system when it comes to health care. And I guess I'm concerned, because if indeed the Commerce Clause in the Constitution can compel us to buy a certain product, then I wonder what it cannot be reached within the framework of economy, any inactivity or activity. I wonder what could not be reached by the Commerce Committee. I'm sorry, the Commerce Clause. And I just think that the chairman put it so well in his opening statement, that those who threw the Boston Tea Party for excessive taxation of tea, I'm wondering how they would respond if their government had told them that they had to buy tea. I think that it might have been even more lively party. Every exercise of Congress's power to regulate interstate commerce has involved some sort or some form of action or transaction and engaged in by an individual or legal entity. The government's theory that the decision not to buy insurance is an economic one would for the first time ever permit laws commanding people, coercing citizens, to engage in economic activity. Now, according to Ilya Shapiro he's a senior fellow of the Constitutional Studies at the Cato Institute, under such a reading, which 2 judges have upheld, Congress would be the sole arbiter of its own powers. The only check would be political. The federal government would have plenary power, plenary authority to compel activities ranging, as we've heard, from eating spinach to joining gyms to lessen the burden on the healthcare system, to coercing citizens to buy GM cars as part of perhaps an auto bailout. And so, Mr. Barnett, let me first turn to you. How would you describe the breadth of this, what I would suggest is a power grab under the Obamacare rubric?
Well, as I said, the Congress has never before tried to impose an economic mandate on the people. So it's a new power, it's a new claim of power, and they've been able to get along without that power for over 200 years. So they're not claiming the power to do other things, but they are claiming the power to do this. And being able to make you do something, being able to make you enter the marketplace rather than regulate you after you voluntarily choose to enter the marketplace is a vast expansion of congressional power, especially when it claims the power to do so, so long as it sees a rational connection between this mandate and its regulation of interstate commerce, or sometimes more broadly put, the regulation of the national economy. It is a vast claim of new power that will, after it's recognized by the Supreme Court, if it ever is, will be solely within Congress's discretionary power to exercise.
Well, Mr. Chairman, I guess I would just express a sense of gratitude to the American people, because the former Congress seemed to be headed in a pretty dangerous direction. The precedent that they were willing to set, you know, if you look at the original version of Obamacare introduced by the former House leadership, it would require families to purchase insurance that the CBO estimated would be $15,000 a year annually. It would require families to do that for the average family of 4. And first of all, I'm wondering if that's what's considered free insurance, $15,000 a year requirement. But under the original version, the even worse potential precedent that they were attempting to set, and I didn't pass, and I'm grateful for that, but it's an indication of the I guess arrogance is the word. The failure to purchase the insurance would have resulted in not only civil penalties, but criminal penalties. And if the head of a household chose to pay medical expenses out of pocket rather than purchase health insurance, the citizen could have been fined $250,000 or sentenced up to 5 years in prison. And I just, I'm wondering, you know, if that kind of provision could be in a health care bill introduced into Congress. If Obamacare is upheld, is there anything standing in the way of such a legal scheme to be instituted in the future? And Mr. Barnett, I'd give you a shot at it, and if Mr. Cuccinelli has a chance.
That's a very good point. As Mr. Dillinger has noted, there are 2 provisions of the current act. One is the requirement that every person have health insurance, and the other is a monetary penalty for the failure to. Those are 2 different provisions. The issue is the constitutionality of the requirement. And if that requirement is upheld, the Supreme Court will certainly say that Congress has powers to enforce this requirement however it wishes to. It has chosen, in its first iteration, to enforce it as a monetary fine or a penalty, in the words of the statute of penalty. That's what it chose to do so now, only applicable to people who pay taxes. But there's no reason, there's no constitutional limit on Congress's power to enforce the requirement once the requirement is upheld as a valid regulation of commerce. So you're absolutely right. That parade of horribles, that parade of severe penalties could easily be upheld once the precedent of the requirement is set.
The gentleman's time has expired. The gentlewoman from Florida, Ms. Wasserman Schultz, is recognized for her questions.
Thank you so much, and Mr. Attorney General Cuccinelli, I appreciate your indulgence, and I'll try to ask my questions rapid fire so we can get you on your way. I know, mentioned in your written testimony that you see no constitutional problem with Congress taxing Americans to pay for government-provided health care. Is that right?
Yes, ma'am.
And you believe that Medicare is constitutional?
Yes, ma'am.
And you believe that Social Security is constitutional?
Yes, ma'am.
And that is because, in your view, Congress is taxing the activity of working?
And the transaction, yes.
Yes.
Voluntarily engaged in.
Right. So in your view, Congress can tax labor in the present to pay for social welfare legislation down the road, and you're fine with that?
The tax, what it goes for, is irrelevant. They have the taxing power.
But something that we can, the concept of taxing labor in the present to pay for social welfare down the road is something that you're fine with? You think it's constitutional?
As a constitutional matter, yes.
Okay. Do you also believe that Congress can regulate activities that substantially affect interstate commerce, as was decided in United States versus Lopez?
Yes.
Okay. Were you aware that in 2008 alone, the uninsured, those who got sick or had an accident and couldn't pay, racked up $43 billion in health care costs?
I've read that in briefs for well on a year now.
Okay.
Yes.
Is $43 billion a lot of money to you?
That'd be a heck of a lot of money. It's more than my state's budget.
It's not more than mine, but it's certainly a lot of money. Do you concede that $43 billion worth of uninsured medical costs substantially affects interstate commerce?
Yes, but it does not give you the ability to compel people against their own desire to enter into a market to address the problem.
Because in United States versus Lopez, which you support, if commerce that is substantially affected, Congress has the ability to regulate. That's what you stated.
If your assertion in that question is that then they can do anything, then you have reduced the necessary and proper clause to the
I'm not asserting that at all.
To the necessary clause. Anything necessary to regulate is therefore within Congress's power. That is simply not the case.
No, the Supreme Court decided that activities that substantially affect interstate commerce, which you just acknowledged that $43 billion is substantially affecting commerce,
right.
Then by connecting those dots, then you would agree that that kind of impact affects interstate commerce significantly.
Not as you have phrased it.
Well, did you know that the average family paid an extra $1,000 last year in their medical insurance premiums due to the cost of the uninsured?
Again, read it in briefs over the last
year. Did you pay for your own health care?
Yes.
Okay. Wouldn't you like to have an extra $1,000 in your pocket?
I'd like to have an extra $1,000 whether I pay for my health care or not.
Yes, well, so would we all. Do you think American families would like to have that extra $1,000 in their budgets each year?
Obviously.
I mean, you would do what with an extra $1,000? Invest it in a bank, invest in stocks, make sure that you could send your kids to college, you could
maybe donate to a Republican in Florida.
Well, may have to look at a different district than mine, but you might be throwing money away if you do that.
Freely and with no compulsion. You're right.
Well, I think we've established pretty clearly that you acknowledge that $43 billion is a significant amount of money, that it significantly affects interstate commerce, and that I think your arguments that somehow we are regulating inactivity by your testimony and your answers to my questions make it pretty clear that the individual mandate is constitutional.
No, actually, your questions used the word activity in your presumption, and that is where you fail.
$43 billion in expenditures is activity.
People deciding not to do something is inactivity. It is the state of doing nothing. If you are going to...
If they go to the emergency room...
Ms. Washburn-Schultz, let's let the witness answer one question.
Yes,
he answered a bunch. Thank you.
If you look at the argument that you're talking about there are two, call them boxes. One is the action of a transaction undertaken. The other is the decision not to undertake a transaction, to do nothing. Now, if doing nothing is regulatable under the Commerce Clause, it literally has infinite reach. If doing
individuals who
nothing
don't
can be regulated,
excuse me one second.
Something can be regulated. That is everything.
Mr. Attorney General, individuals who have to go to the emergency room to get their health care, which is part of that $43 billion, is not inactivity. And that is activity that we all pay for. So
And
it,
you can
as
regulate
a result,
at that point,
substantially affects interstate commerce.
And you can regulate at that point, and the federal government,
Which is-
by its own law, has
which is
compelled
what-
the treatment that causes, in part, the costs you're identifying. So the federal government has trapped itself into a financial corner and then says, hey, we're trapped in a financial corner. Give us new constitutional power so we can get out.
It's certainly
that
not,
doesn't hold water.
The
simply
gentleman,
not new power.
the
It is
gentleman's
existing power.
time has expired.
And I do appreciate the Attorney General's indulgence. It was a pleasure bantering with you.
Yes, ma'am, for me as well.
Thank you, Mr. Attorney General. Appreciate your being here. The gentleman from Texas, Mr. Gomert, is recognized.
Thank you, Chairman. And I think most of us would agree, including General Cuccinelli, that the right to regulate is far different from the right to mandate. And in fact, if this Congress did a better job of regulating rather than trying to run people's lives, this country would be a whole lot better off. And in fact, if the federal government, for example, did a better job of regulating fraud and illegal activity with regard to stocks, then perhaps we wouldn't have the Madoffs out there taking advantage of people. But this government has gotten so interested in mandating and running people's lives that we've lost sight of the job that's really important, and that is regulating, making sure there's a fair, level playing field for people to play on. We've been so busy being players on the field and referees that we have really skewed what the original intent was of the Constitution. And so we hear all this talk about car insurance. Let me ask the witnesses, are you aware of any state in the Union, in the United States, that mandates the purchase of car insurance in order to reside in that state? Either?
No.
Because I keep hearing that brought up. Car insurance, states can mandate car insurance, but I know, as smart as both of you are, you know that no state mandates the purchase of car insurance unless a resident decides to take advantage of the privilege of driving on the state's roadways, correct?
That's correct. What is similar about that particular mandate is that the reason that is one of the rare items that people are compelled to purchase if they to operate a motor vehicle is that no one can be assured that they're just not going to have an accident and impose costs on other people. And so here as well, no one can be ensured that they're not going to use health care.
Well, now let's go back. I haven't asked about health care yet because I'm wanting to go after this metaphor of car insurance purchase. The fact is, there's not a state in this country that requires anybody to purchase car insurance on themselves in order to have the privilege of driving on the roads. Every state that I'm aware of requires the purchase of insurance to protect against damaging someone else. But you don't have to buy insurance to drive on a road to cover your own damages.
Yeah.
So that is another difference from car insurance. This is the federal government going in and saying, for the first time ever, we're requiring not only the purchase of a private product, but we're requiring you to purchase a private product that must be used on yourself. Well, that seems pretty significant.
What is similar is that in both cases, the cost is imposed on other people. When you have a car accident and impose costs on other individuals, liability insurance means that there's going to be a way to pay those individuals. When the uninsured use hospitalization, they wind up paying only 10%.
Who is they, sir?
The uninsured. Uninsured pay only 10% of the hospitalization costs that they...
Do you know how much insurance companies pay on the cash value of services that are rendered? I know from some lawsuits in which I was involved, you've got insurance companies that pay about 10% of what someone who doesn't have insurance has to pay. So there are all kinds of problems with the system, the way it's set up. We could regulate that system. We could require free market competition, which we don't have and can't have as long as nobody really knows what insurance companies are paying, what pharmaceuticals get paid, what somebody really could get away with paying if they work out a deal with cash. Those are the kind of things we ought to regulate, and then people don't have to be paying for everybody else's. But again, I see I'm running out of time, but let me just say with regard to my friend from Georgia who brought up Supreme Court justices, I wish I had heard from my friends across the aisle the sense of outrage and also from Common Cause, the kind of outrage they're expressing and the racial hatred they're stirring up by doing so. If they had raised that kind of issue over an ACLU leader sitting in judgment on cases involving the ACLU, or a Supreme Court judge who's been a Solicitor General sitting on cases in which the Solicitor General was involved, I think it would have a lot more credibility to raise it at this point. And with that, I yield back.
Thank you, Mr. Gomer. The gentleman from Florida, Mr. Deutsch, is recognized.
Thank you, Mr. Chairman. First of all, Mr. Chairman, I would, as a member of the other side of the aisle, take offense to the suggestion that those in my caucus are somehow stirring up racial hatred. I think it's an inappropriate comment.
Will the gentleman yield?
I will.
I didn't say that. I was addressing Common Cause that stirred up demonstrations that created racial epithets and threats to Supreme Court justices and their family. I'm not aware of anybody on the other side of the aisle stirring up that kind of issue, and if I indicated that, I did not intend to. I was referring to Common Cause.
Thank you.
So thank you.
I'd
ask unanimous consent that he have additional time to make up for what I said.
Without objection, the gentleman from Florida is yielding an additional minute.
Thank you, Mr. Chair. We've been able to do the one thing that all of us believe in. With the General's departure, we have leveled the playing field. I have some questions for both of you. Professor Dillinger, you spoke earlier about the fact that, and we've now confirmed with the General, that it is constitutional to require the purchase of old age survivors and disability insurance, that being Social Security. It is constitutional to make payments, health insurance payments throughout one's working life, with those benefits to then be paid out upon retirement. That's Medicare. So I'd like to understand then why this is different, but I'd like to play it in a different direction. Professor Barnett, if the federal government enforced an individual mandate by deducting premiums from Americans' paychecks and providing individuals with a coupon to buy private insurance that they would have to be required, mandated to buy from a private insurance company, would that be constitutional, in your opinion?
Mr. Congressman, this actually gets back to Mr. Scott's earlier question about labels making a difference. I agree with you that labels make a big difference, and Congress does have a tax power. It's a label given one of your powers, the tax power. And when you exercise that power, you can collect revenues, and then you can then spend those revenues for the general welfare, to provide for the general welfare and the common defense. And the programs that you just mentioned are an exercise of that tax power. And the constraint on the tax power that's provided for up till now is political. And that's the reason why Congress doesn't like to exercise it so much, because when they do exercise the tax power, they have to pay a political price for doing so, so they might rather call it something else. So labels actually do make a difference.
So collecting taxes then and handing out coupons and requiring that those coupons be spent in the private market, that's acceptable. That's constitutional.
That would be an exercise of your tax and spending power, Congressman.
And what if individuals had the option to purchase publicly run health insurance in the exchange? I guess the question is, would public ownership of a health plan affect the interpretation of the constitutionality of the market, of the mandate?
I think the simplest way to put this is, if Medicare is constitutional, then Medicare for everyone is constitutional.
So single payer clearly would be constitutional.
Yeah.
Would an even greater exercise than of a single payer finance through new taxes and automatically provided to all Americans, that would clearly be constitutional.
I'm sure.
If we had an additional tax that was used to finance a publicly created entity to provide health insurance, that's clearly constitutional.
Yeah.
And so how much more government intervention is required to make the Affordable Care Act constitutional?
There is no principle of constitutional law that measures the degree of intrusiveness of constitutional power. You have a list of powers in Article 1, Section 8, and some of them are very intrusive and some of them are not. One of the most intrusive powers you have is the power of taxation. That's the reason why the general public is very sensitive to when you invoke that power. And candidates run for public office pledging they won't invoke that power. So the label makes a big difference in terms of the constraint on that
Professor,
power. But you do have that power.
Thank you. Professor Dillinger, would you flesh out that distinction between the Affordable Care Act provisions and the proposed privatization of Medicare, which would provide coupons that would then mandate individuals to use those coupons in the private market?
I think what's important about that example is that functionally it would be the same, and yet there would be no doubt about one being valid. The rhetorical arguments wouldn't even be available to challenge it. And so you have to ask whether it can possibly be some great incursion in liberty if you're merely talking about the way in which you label matters. But I think your question leads to an even more profound point, which is much of the argument against the purchase requirement, or the requirement that you maintain insurance, is that it's novel. Now, all new laws are novel, but this is novel for a particular reason. This is really the first time for a major social program that Congress has chosen a market approach, giving American citizens greater choice and giving them the choice among private providers rather than doing it through an imposition and a monolithic government bureaucracy. And that's what's novel.
Right. Professor Dillinger, I'm sorry, I'm running out of time. Just for Professor Barnett, the last question then is, why shouldn't Congress be able to require individuals to assume responsibility for their own health care when their inaction on the issue has a direct and negative impact on society? Why don't we want, you spoke earlier about the things that we politicians run on. Well, a lot of us also run on individual responsibility. Why shouldn't we be expected to impose some responsibility on American citizens to take responsibility for themselves?
You certainly may, Congressman, as long as it's within one of the powers that's given to you by the Constitution.
Thank you. Mr. Chairman, I'll yield back.
Thank you, Mr. Deutsch. The gentleman from Pennsylvania, Mr. Marino, is recognized.
Yeah, thank you, Mr. Chairman. Gentlemen, I have to admit that my constitutional appetite has been fully satisfied today with your discussions. I really appreciate that. Professor Dillinger, I'm not a betting man, but I think I'm forced to take you up on your bet. Okay. Not with who may write the opinion, but the outcome of it. We shall see.
We shall see. And I will send a note to your constituents saying what a fine and outstanding person you are if you prevail. And you can hold me up to ridicule if...
I would never do that. I respect your intellect and your arguments here today. This question is to both of you, but please, Mr. Barnett, would you start with this? My question is, there was discussion about if the Supreme Court does rule this is not unconstitutional, and then sending back to the Congress for further legislation as to how the health care program would be implemented, the limitations. Does that not move the line, the scrimmage line, down the field for further issues concerning constitutionality of what Congress can do as far as implementing any particular program or any particular thought that a congressman or woman has in mind promoting their cause? Do you understand my question?
really all that's at issue here, Congressman, I believe, is whether the Constitution gives Congress the power to impose economic mandates on the general public.
Right.
So that's what the Supreme Court's going to have to decide one way or the other, and your guess is as good as mine, perhaps how they're going to rule. If they should uphold the power for the first time to impose economic mandates on the general public, then we're going to have to, then at that point, when Congress now has this new power that it's never needed to exercise before, there's going to be an awful lot of future litigation, or at least future issues about when that power can and should be employed and when it cannot be. But generally speaking, the court will defer to Congress's judgment about when it may exercise one of the powers that the court thinks Congress has. So once they've acknowledged this power, chances are at that point, it's going to just be a matter of Congress to employ this new power that it has.
Professor Dillinger.
You know, I think a lot of your colleagues have asked questions in the following form. If this is upheld, then can't Congress do anything? And the answer to that is, if the Supreme Court were to uphold this requirement on the grounds that Congress can do anything, then indeed Congress could do anything. But they won't. And the reason I think Chief Justice Roberts will write the opinion is because I think he will want to write a narrow opinion. He won't want to say that the market alternatives are ruled out and you can only use monolithic government alternatives. Will write an opinion to say that this is upheld not because Congress can use its commerce power to impose affirmative obligations willy-nilly to purchase products, but it's upheld because of all the reasons we've said about the central role it plays in avoiding the displacement of cost onto other citizens. And if that's the opinion the Supreme Court writes, then only things that fit within that parameter will be regulatable by Congress, and I think that will be a very small set.
Right.
Congressman, you have yet to hear from my friend, Mr. Dillinger, and he truly is my friend, actually. It's not one of these things we just say to each other. We've known each other for a long time. And you have yet to hear from Attorney General, former Solicitor General Freed, who was my torts professor in law school, any constitutional limitation on this new claim of a power to impose economic mandates. Yes, healthcare is unique, it's different, it's free rider problems, it's this or that. Those are not constitutional principles. I agree. If the mandate is upheld, the opinion will be written like that. But it will not impose any future constraint on the use of this new power once it's acknowledged. And that's why you're having this hearing, because there's a lot at stake at what's going to happen going forward.
Gentlemen, thank you. I have no further questions. I yield back my time.
Chairman Smith, I have my own individual mandate that I may need a couple of minutes to take care of, if that's if that's possible. I'll trust Mr. Barnett not to say anything completely dishonest while I'm down the hall. If you would
we've had a request for a seventh inning stretch, and we will take 5 minutes to recess and then resume our hearing. Trey, how are you doing?